All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So, Phil, the first one I want to talk about today is we've been talking about this Department of Government Efficiency, or DOGE, that President Trump has set up, that's being led by Elon Musk and Vivek Ramaswamy. And one of the priorities of DOGE is to require federal employees to return to the workplace. And if they don't return, they're going to lose their jobs. They have publicly announced this. Well, not to be outdone by DOGE, President Biden has given 42,000 employees, government employees of the Social Security Administration, a gift on the way out the door. And what they have done.
Well, tell me about that. How was that gift packaged?
Yeah, well, what this gift was packaged as is until the year 2029, remote work is still available to the agency's 42,000 employees who are members of the American Federation of Government Employees Union. And so this union and the government negotiated a new contract that provides for remote work through 2029 for these 42,000 government employees. So really an effort to undermine DOGE and try to get people back to work. And if people didn't want to return back to work, they were hoping to have some attrition in order to save taxpayers money.
Yeah, I have all kinds of thoughts about that. But I think what is interesting more than my opinions and thoughts on return to work, because most people that watch the program know that I'm not a big fan of working from home. However, what I find interesting is that the union was negotiating those working conditions, and that might be a little bit unique, but I bet it's not uncommon today for remote employees that are part of a bargaining unit, or for employees who can work remotely to be a part of the bargaining unit, for that to be in a contract. Have you experienced that yet in your dealings so far?
I really haven't, and that's because I just, in my own practice, I don't represent call centers that are members of a union. Most of my union clients are either construction or manufacturing, which requires obviously on-site presence. Yeah, exactly. But I think if you're dealing with a unionized call center or something along those lines, that very well may be a subject of bargaining.
Yeah, that's interesting that was the topic of part of the bargaining. That's a nice gift packaged up just in time for the holidays for the Social Security workers. And we'll see how Mr. Musk manages that as he goes forward with his return to work programs.
Exactly.
Yeah.
All right. So moving on, Phil, to the next one here, I want to talk a little bit about a J.D. Vance-led effort to ban diversity, equity, and inclusion in corporate America. This effort that's making its way through Congress right now definitely is not going to pass in the next 8 weeks while Biden's in office and while the Democrats still control the Senate. But I think what it does is it gives a preview of what you're likely to see under the Trump administration. So basically, under this bill, it would bar the U.S. government from hiring corporate contractors with pro-DE&I practices and redefine DE&I as discrimination by actually amending the Civil Rights Act of 1964. So again, this bill is not going to pass in the next 8 weeks. It's probably not going to pass even when the Republicans get in charge. But it does show what the priorities will be of the administration and of the next Congress. Of course, opponents of DE&I argue that it's a form of reverse discrimination because it tips the scale in favor of historically marginalized racial, ethnic, and gender minorities. The opponents of this also point to the Supreme Court's June 2023 ruling, which limited affirmative action in college admissions. And according to Vance, he says the DE&I agenda is a destructive ideology that breeds hatred and racial division. So again, that's coming from Vance. But I think the reason I'm talking about this is that it really does show where this next administration is going on those efforts.
Yeah, that's an interesting one to keep our eye on and to watch how that unfolds. I think I agree with you. I don't see that probably getting off the ground, but it does set a tone, I think, for the next 4 years that we may see from the current administration.
Well, for sure, and it's interesting because in order for such a bill to get passed, the Republicans will have slim majorities in both the House and in the Senate. Remember all the talk during the last 4 years about eliminating the filibuster. Well, now the Democrats have completely changed their tune on the elimination of the filibuster, because that's going to be their mechanism for stopping a piece of legislation like this from going through. It'll be interesting because there are going to be efforts, and I do think we're going to see more court cases, because the law as drafted right now, as we've talked about many times on the program, says Title VII says you may not use protected characteristics in making employment-related decisions. And so I agree with what the Supreme Court, I agree with their ruling from a legal standpoint, is it applied to college admissions. And I think that ultimately that legal reasoning would bear its way, would make its way through to cases regarding DE&I, if DE&I efforts are challenged and they make it up to the Supreme Court. In order for race or gender to be allowed to be a characteristic that people can use to make hiring decisions, the law itself has to be changed.
Yeah, no, that's interesting. We've said it here. We've been talking about it for well over a year and a half now. If you do engage in DE&I efforts within your organization, we're not saying that that's right or wrong in any measure. What we're saying is let's make sure that we're doing it in a way that keeps you and your organization protected from unintentional consequences. So, contact Bert or myself and let us take a look at that and help you. Just make sure you're doing the right things and you keep yourself and the organizations out of trouble.
That's exactly right. It needs to be done very carefully if you're going to wade into that.
That's right.
Yep.
Anything else you got there, Bert?
Yeah, Phil, I've taken upon myself to try to come up with something a little bit lighter for the.
Oh, this always worries me. This always worries me.
For the
Matt, this is what I deal with every week right here. I've taken it upon myself, and when people lead with that, imagine your kids come into you and go, "Hey, Dad, I've taken it upon myself." Right then, you just want to say, "Stop."
Yeah.
All right, Bert, what do you got?
All right. So there's a case pending in the North Carolina federal court where a judge denied a motion to dismiss the employee's lawsuit. This particular employee complained that she was unlawfully fired because she complained about a coworker who was walking around in his underwear and penny loafers. And she said that she was terminated suspiciously soon after she accused this employee of sexual harassment. And so, she complained that she was sexually harassed by this individual. Now, interestingly, the court got rid of the sexual harassment claim, saying it did not rise to the level of actionable sexual harassment. It was not severe or pervasive. Her being subjected to this truck driver walking around in his underwear and penny loafers on one occasion. And I agree. I think that is not necessarily severe or pervasive. But what did happen is that she claimed she was also fired suspiciously 1 month after making her complaint. The trucking company said that she was fired for having a number of driving infractions. But guess what was missing from her personnel file? Any complaints or reprimands for having driving infractions. And so the judge said, yeah, this is a question for the jury. While her complaint of sexual harassment in and of itself is not actionable, her complaint of retaliation, that she was retaliated because she made a complaint of sexual harassment, that case gets to stay. And a jury ultimately is going to get to decide whether she was fired for complaining about the sexual harassment incident. And, I think it just serves as a really good reminder, Phil, of behavior not to engage in while you're in the workplace. And, frankly, I think walking
Are you
around
saying
in
that don't walk around in your underwear and penny loafers is the behavior not to engage in?
Probably not the best idea, because had the truck driver not been walking around in his underwear,
I got to make a note of that. One minute here, Bert. Okay, no underwear, penny loafers. Okay, go ahead.
Wait, Phil. No, please keep the underwear and the penny loafers on, but just have some other clothes on them. Then you're going to get us into an even worse.
No point made. A correction. Okay, right. Got it.
Yeah, I think just in terms of behavior not to engage in the workplace is probably one to avoid, because had the truck driver not been walking around in just his underwear and penny loafers, this whole dispute could have been avoided.
Yeah. Where I thought you were going to take that is that, this happened, I think you said like 30 days ago or so. So I'm thinking this is a Halloween costume. Someone wore their underwear and penny loafers as they're, dressed as a baby or something like that for a Halloween costume. And that became a complaint. And therefore, us having Halloween costume parties, we would need to have guidelines on appropriateness. So yeah. I thought that's where you were going, but this is actually a little bit more serious than that. Yeah.
Indeed.
Okay, very good.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.